James Garner, is James Garner here?
I'm here.
Hey guys, welcome back to the channel today. We're stepping inside Judge Perkins' courtroom. This hearing starts calm, but tension is already in the air. The defendant walks in confident and unbothered hat scarf attitude, fully intact. You already know where this is headed. This is not his first time here and definitely not his first mistake. The charges are stacked, the patience is thin, and the judge is already clocking the behavior, sovereign arguments, loathing procedural reality. Incoming, this courtroom does not play games, and today the wrong buttons get pushed. Let's get into it.
Good morning to you, sir.
Good morning.
What is your middle name? Can you remove your hat, please? And your scarf. What is your middle name, Mr. Garner?
Errol.
Earl?
No.
He's on the 1:30 docket, Your Honor, I believe.
James Garner. Earl Garner. James Errol Garner, right?
Yes.
You are on the 1:30 docket.
If you want, Your Honor, I can give House Counsel an offer right now. She can report it to him.
On James Garner, do you see all the cases he has?
I see just the 4 that are on the docket. Or 5.
Yeah.
You've got more?
He's got plenty more.
Okay. You want me to come down, review, and do a global offer?
If you could, please.
Okay, I'm on my way down.
Mr. Garner, do you want to offer on these or do you want to go to trial?
I would like to know what the charges are.
This moment looks simple on the surface, basic introductions, basic questions, but pay attention to the details. The judge asks for compliance and instead gets resistance. The hat becomes symbolic, not about fashion, but about authority. Small requests matter in court, especially on a busy docket. This judge is managing chaos efficiently, and this defendant is already behind because respect sets the tone, and the tone is already off. This is where things quietly start going wrong.
Okay. This is the city of Detroit versus James Earl Garner. Case number SP 11000435, counts 1, 2, and 3. SP 116950. Those are driving license expired, misdemeanor, no insurance, insurance misdemeanor. Thank you. And an improper plate misdemeanor. All of them punishable by maximum possible penalty of 93 days in jail and or $500 in fines. SP 1169507. Counts 1 and counts 2, expired license and no insurance misdemeanor, both punishable by 93 days in jail and or $500 in fines. SP 1169521, same improper plates, same punishment, $500 and 93 days in jail and or $500 in fines, maximum possible penalty. SP 1223079, driver license suspended. SP 127-37681, SP 129-27512. 3 of those tickets are all punishable by 93 days in jail and or $500 in fines. SP 1547006, counts 1, counts 2, and counts 3. Those are civil infractions. SP 1547407, counts 1 and counts 2. Count 1 being a driver license suspended repeat offender. This one is in warrant status, probably an old case that he didn't pay. SP 800104, counts 1 and counts 2. 1 being an unregistered untitled. He owes $1,194 on that. SP, and count two of that is a drove while licensed improper. It looks like he has a $114 fine on that. State of Michigan versus James Earl Garner, case number SX 36268561. That is a drove while license expired. And that will be $500 maximum possible penalty, 93 days in jail and or $500 in fines.
Now the charges start rolling in, and they just keep coming: expired license, no insurance, improper plates, suspended license, repeat offenses, civil infractions. Stacked on top, this isn't one mistake, this is a pattern. Paperwork tells a story, and the story isn't good. 17 charges total, all avoidable, all preventable, but belief overrides reality here, and that belief is about to get tested.
For the record, please.
Sherika Harris on behalf of Mr. Garner. Mr. Garner, please state your name for the record.
First off, I do have a couple.
You got to state your name first. You got to state your name first.
No,
Let's start there.
Wait a minute, Ms. Harris. Wait a minute, Ms. Harris. I think Mr. Garner is going to represent himself. Am I correct, Mr. Garner?
I'm representing myself in what? I mean,
This is where self-representation enters the chat. No lawyer, no buffer, no protection from himself. The public defender steps back calmly. She's seen this before many times. The confidence is loud, the understanding is not, and the judge immediately recognizes it, because pro se defendants always think they cracked a hidden code, but court isn't a debate club, and feelings don't override statutes. This choice sets the stage for everything that follows.
I'm confused about what's actually going on. First off, who's alleging these charges? That's what I'm curious about.
State of Michigan, City of Detroit.
Okay, well, if that's the case, there's a common law principle which states that for there to be a crime, there must be a victim. Corpus delicti. The state cannot be the injured party. And in the absence of a victim, there can be no crime.
We want to do it.
Drawing my name from the record on that one. Thank you.
I know. How do you want to proceed, Mr. Garner? You set the matter. I'll enter a not guilty plea on his behalf. Give him a $0 bond. Either set the matter for trial, or I'll wait for the city to give you an offer. What do you want to do?
Well, the court hasn't even established jurisdiction. I mean, in order for jurisdiction, the jurisdiction has to be established first, and there's no jurisdiction established. And once jurisdiction is challenged, that must be settled before charges can be brought.
Now comes the classic argument: no victim, no crime, the sovereign citizen starter pack. He believes this is a checkmate, but the court has heard it 1,000 times. Jurisdiction gets challenged, phrases get repeated, logic gets circular, and the judge listens once, then responds clearly. Motions must be filed, not recited, because court runs on procedure, not internet theories, and this gap in understanding is dangerous.
All right. Do you want to put that in a motion, sir?
As far as I'm concerned, any and all charges must be dismissed because there is no complaining witness, and the state cannot be.
I'm not gonna listen. If that's your motion, I'm gonna deny the motion. Okay. So all we're gonna do now, we're not gonna keep going back and forth. Either you take an offer or you set the matter for trial. Which one do you want?
Respectfully, in order for this to continue, there must be a complaining witness, and the state cannot be a complaining witness. Now, if I'm entitled to a fair trial, the law states there must be a victim. I'm just requesting, who is the victim? Who did I injure?
The citizens of the city of Detroit and the state of Michigan are the victims.
The state cannot be a victim. And if that's the case,
I said the citizens of the city of Detroit and the state of Michigan are the victims.
if that's the case,
Mr. Garner, can we just go into a breakout room and then maybe I can give you a little bit of advice to assist you with moving forward? Would you be agreeable to that?
Sure.
Okay, awesome.
Watch how the judge tries to redirect. Simple choices are offered: trial date or plea, offer nothing complicated, nothing hidden, but the defendant refuses the lane. He wants control of the script, and court doesn't allow. The interruptions pile up. Warnings get clearer. The patience line is visible now because compliance is required, not negotiated, and when someone refuses to answer directly, consequences move closer. This is the tipping point.
Representing himself.
Let's go back on the record with Garner. What do you want to do, Mr. Garner? Do you want a trial date, or you want an offer? Those are really your only two options.
Okay, since we are on the record, all I'm asking for is the
Okay, one last time. Now listen, here's how it's gonna go from this point on. If you don't answer the question that I asked specifically, then I'm gonna hold you in contempt of court, and we're gonna move from that point on, right?
This warning is not symbolic, it's not dramatic flair, it's a final line. The judge explains exactly what will happen: answer the question or face contempt. And this moment matters because it's documented, clear, unambiguous. The defendant talks anyway, overrides the court, adds commentary, refuses direction, and at this exact moment control leaves his hands because courtroom authority is absolute and contempt is no joke.
So you're telling me,
Mr. Garner, we're not gonna have a
court is just gonna violate the
conversation. Stop, sir. Now, that's the last time I'm gonna ask you to.
On the law. Is that what I'm hearing?
All right.
I'm asking.
I'm gonna hold Mr. Garner in contempt of court. He is directly violating the court's order. I've asked him repeatedly to not interfere or add any extra commentary to this case. I've given him ample time to answer the court's question, and he continues to refuse to do so. So now I'm going to hold you in contempt, and I'm going to sentence you to 30 days Wayne County Jail, no early release.
So that means that the court is just going to violate my rights because I'm defending myself? Is that what I'm hearing?
30 days, Wayne County Jail, no early release.
The ruling comes fast, no hesitation, no debate. 30 days, Wayne County Jail, no early release. This isn't about the charges anymore. This is about behavior, disrespect, and refusal to comply. Contempt is punishment for the courtroom, not the crime, and judges use it to protect order. The irony is heavy because he asked for his rights and lost his freedom instead. All over talking too much.
That'll give you some chance and some time to read up on your rights, okay? Fill out the contempt papers, Madam. So I'm gonna order you to turn yourself in today, Mr. Garner, to start that jail time, okay?
So I have a question.
I'm not answering any more of your questions. Turn yourself in to the Wayne County Jail today.
So the court is going to be in direct violation of my rights in the law. Is that where we're standing?
That's how you feel. Have a good day, sir.
Even now, he doesn't understand. He asks questions instead of complying, but the decision is final. Turn yourself in today. No delays, no loopholes. This is the cost of ignoring warnings. We've seen this pattern before. Other defendants, same courtroom, same result. Judge Perkins is consistent, fair but firm, and once contempt is triggered, there's no arguing your way out, because court authority must stand. This case reminds me of others, just like it, where confidence replaces competence and ego replaces strategy. 30 days doesn't sound long until you're sitting in a cell over behavior, not charges. Court isn't the place for theories or internet law. It's a place for listening and answering direct questions. This situation could gone very differently with one simple choice, but here we are. If you found this breakdown useful, hit the like button, drop your thoughts in the comments, subscribe for more courtroom analysis, and I'll see you in the next one.